Good afternoon, everyone, and welcome to our 2020 EMP Year in Review. I'm Kathryn Pacey. I'm a partner in the Environment and Planning team here in Brisbane. I'm joined today by Motti, who's a Senior Associate in our team, and Trainor, who is also a partner in our team. Before I start, I'd like to acknowledge the traditional owners of the lands on which we all meet, wherever that may be, and pay my respects to their elders past, present and emerging. This event we would generally do at twilight with a nice glass of wine and some cheese platters, but it is 2020, so we've pivoted, I think is the word for 2020, onto the webinar format, so welcome to the new world. As this is a webinar, you'll find that you are all muted, but you can submit questions, and we encourage you to submit questions because it is a bit lonely in the room. There is a question panel on the right-hand side of your screen, and we will endeavour to deal with your questions at the end of the seminar. The seminar is also being recorded, so everything we say is preserved for all time, and it will be provided to you in the next couple of days as well. And as a wonderful starter, does yours work? Ah, Karen's now driving my slides, thank you. So the things that happened in 2020, besides the obvious world pandemics, is that we had the independent review of the Commonwealth Environment Protection and Biodiversity Conservation Act. We had a raft of new climate change cases, which we'll look at. Ian's going to talk about the new koala protections for SEQ and nature conservation changes, and also the offsets review, which has been a long time coming but seems to have finally started, as well as enforcement and compliance trends for 2020. Karen's going to take a bit more of a forward-looking crystal ball and look at what's happening for 2021, including what's happening in the rehabilitation space for resources projects. Thanks, Kathryn. So the EPBC Act interim report was released in July. It was provided to the government in June. That report was part of the statutory review of the EPBC Act, which has to happen every 10 years. The report identified a number of recommendations, the key being that there should be legally enforceable national environmental standards that will underpin the balance of the reforms recommended by that interim report. One of the recommendations that has been embraced by government and was embraced by government before the interim report was the devolution of the approval powers to the states and to other entities, which the government called the single touch approvals. And that's been put into a bill that's currently before the Senate, which we'll talk about shortly. There were a raft of other recommendations made in that interim report, which had to do with how decisions under the EPBC Act should be legally reviewed, increased Indigenous involvement in decision-making and protection for Indigenous cultural heritage, better access and data management, and there was a recommendation for what was called an independent cop on the beat for compliance enforcement and assurance. No changes overall to the matters of national environmental significance were recommended, including there was no recommendation to introduce a greenhouse gas trigger, which was the subject of many submissions to the review. The key finding overall, which has been quoted quite a number of times in the last few months, is that Australia's natural environment and iconic places are in an overall state of decline and are under increasing threat, and that our current trajectory is unsustainable. The review also found that the Act is ineffective and does not fulfil its role in protecting and conserving environmental matters that are of national significance. So the final report has been handed to the Commonwealth Environment Minister. It was handed to her a day early on 30 October, which was a Friday. The report has not yet been released. So the Minister has 15 sitting days to table the report before each House of Parliament. We know from the Senate hearings that were held on Monday that there is an updated version of the National Environmental Standards that has been attached to the final report, and consultation on those standards has been undertaken on a limited basis with a stakeholder group. Now, just after the interim report was released, but I don't think in response to the interim report, the government introduced the Environment Protection and Biodiversity Conservation Amendment Streamlining Environmental Approvals Bill of 2020. It's passed through the House of Reps and is currently sitting with the Senate. On the 12th of November, it was referred to the Senate Environment and Communications Legislation Committee for inquiry, with a very lengthy reporting date set for the 27th of November 2020. And the public hearings for that committee were held on Monday. The committee, despite the very short time frame, has received over 90 submissions about the bill. The bill, if you can cast your minds back to 2014, is almost identical to the approvals bilateral bill that was introduced by the Abbott government, I think, in 2014, and it failed to pass the Senate at that time. So there is actually very little difference between the current bill and the 2014 bill. What the bill does is effectively makes amendments to the existing approvals bilaterals provisions of the EPBC Act to facilitate the devolution of approvals to the states and also to other authorities, including conceivably local governments. The bill also removes the restriction on the ability for the approvals bilateral to apply to the water trigger, so what was called the Windsor Knot, when the water trigger was introduced to the EPBC Act, prevented that being devolved to the states. The bill proposes to remove that restriction. There is also additional flexibility proposed in the bill in terms of what processes can be accredited, who the decision makers can be, and to facilitate the states being able to make minor amendments to legislation without affecting the approvals bilaterals. Significantly, and this has been a criticism of the bill, it does not include giving legislative effect to the national environmental standards. That may be partly because no one but a limited stakeholder group has seen the national environmental standards as they are attached to the final report, which has not been released, and also there has not yet been government endorsement of those national environmental standards. It would be expected, I think, that the national environmental standards will continue to be developed as time goes on. From the transcript of the Senate committee on Monday, it appears that government does have a draft bill to give effect to those national environmental standards if that's the process government decides to adopt. So moving on to climate litigation, which is ever increasing. I just wanted to touch briefly on 4 cases, one of which is just settled, and the other 3 which will be ongoing into the new year. The case of McVeigh and Rest Super settled, I think, literally on the steps of the courthouse just before they started a 3-day hearing in the federal court. McVeigh started proceedings against Rest Superannuation on the basis that the super fund breached their fiduciary duties by not exercising care, skill and diligence to protect his retirement savings from the financial risks posed by climate change. As part of the settlement, REST has released a statement on their website where they acknowledge that superannuation is exposed to the financial, physical and transitional impacts associated with climate change, and REST has undertaken to take further steps to consider, measure and manage financial risks posed by climate change, and also increase disclosure to members on those risks. The next case is the case of O'Donnell and the Commonwealth. So this is a class action that has been commenced against the Australian Government for failing to disclose climate change risks to investors in sovereign bonds. The case argues that climate-related risks should be disclosed in information documents to sovereign bond investors on the basis that those who invest in Australian government bonds face substantial climate change risks which require disclosure. So Kathryn O'Donnell, who is the applicant in this case, owns Australian government bonds that mature in 2050, by which time the impacts of climate change are expected to be severe. The allegation is that by failure to disclose, the Commonwealth has breached its duty of disclosure and has engaged in misleading and deceptive conduct, and has failed to act with the requisite standard of care and diligence of a reasonable person in their position. It is almost analogous to the director's duties that we're seeing emerge through the climate cases as well. So it's novel in that it's trying to apply those duties to government. That case is expected to be heard in 2021. I think pleadings are due in the next couple of weeks. The next case is an interesting one. It is Sharma and the Minister for the Environment. So this is a class action on behalf of every person in the world under the age of 18 that has been commenced by 8 teenagers between the ages of 13 and 17. Because of their age, they need a litigation guardian who's an 85-year-old Catholic nun called Sister Bridget Arthur. So the teenagers are seeking an injunction to restrain the Commonwealth Environment Minister from approving Whitehaven's Vickery coal mine expansion. The case is quite novel. It is based on the minister owing effectively a common law duty of care to protect vulnerable or young people in making decisions under the EPBC Act. The case has just been set down for a 5-day hearing, which is set for March 2021. The Minister has extended the decision-making date for the Vickery expansion to the 10th of December, but I expect that will be extended again. And the final case, which is a very 2020 case, is a class action for the bushfire survivors for climate action against the New South Wales EPA. And this is a case which is challenging the response that the New South Wales EPA has given to climate change through their policies. The case has had some interlocutory proceedings, which included a notice of motion to file and serve expert evidence from Professor Penny Sackett, who's a climate scientist at ANU, in relation to 6 specific points. One of those points is to what extent have anthropogenic greenhouse gas emissions caused a long-term increase in extreme fire and in the length of the fire season across Australia. For each of the 6 points, the judge did confine them so that the evidence would have to look specifically at how that would impact on the environment of New South Wales. The notice of motion was allowed, but the judge did recognise through that the admissibility of that evidence would be a question for the trial judge to resolve. So it will be interesting to see how that case evolves throughout next year. I'll hand over to Ian. Thank you.
Well, in a year like 2020, could be forgiven for missing some of the regulatory changes that have taken place. What with border closures and remote working, virtual meetings, ISO baking, and of course the constant doom scrolling. One of those changes has been to koala protections in southeast Queensland, which actually occurred back in the dim dark past of February 2020 BC, or before COVID. If you did miss it the first time around, I'll take you through some of the key changes, but I'm pretty sure you might have been busy doing other things, like that other virtual trend of 2020, trying to work out whether everyday things were cake or not. So, as I mentioned, there's been a number of developments in the nature conservation space, starting with the introduction of new koala mapping in February 2020 to support the draft Southeast Queensland Conservation Strategy. The updated mapping identifies new koala habitat area, or KHA, for Southeast Queensland, and the new mapping, together with legislative amendments, regulates activities that can occur within that koala habitat area. This covers approximately 690,000 hectares across southeast Queensland. And following its introduction in February, updated mapping was actually released in August 2020 with the release of the final Southeast Queensland Koala Conservation Strategy. That updated mapping increased the amount of KHA protected across southeast Queensland by another 24,000 hectares, taking the total to approximately 716,000, which is now regulated under the new planning framework. The koala mapping is set to be formally updated annually, and that will occur in April 2021. However, landowners can apply to have mapping revoked, amended or made in relation to their properties at any particular time. One of the key features of the koala habitat mapping is the introduction of koala priority areas within that habitat. The legislative amendments which the mapping supports was introduced by the Nature Conservation and Other Legislation Koala Protection Amendment Regulation, which in turn amended the Nature Conservation Koala Conservation Plan of 2017, which effectively gave a force to the mapping. It also amended the Environmental Offsets Regulation for a new policy, the Planning Regulation for a new assessment benchmarks in relation to koala habitat, and Vegetation Management Regulation in relation to vegetation protection. Generally speaking, those amendments operate to provide that interference with koala habitat that is in both a koala habitat area and a koala priority area is prohibited development unless an exemption applies. Exemptions apply for development in state development areas, priority development area related development, particular infrastructure which is carried out by state or public sector entities, public housing and development for coordinated projects. Interfering with koala habitat in a koala habitat area but outside a KPA is assessable development, which is assessed against the new State Code 25 of the STAP. Again, unless it falls within one of those exemptions. And I should mention that the range of exemptions is broader than what I've just mentioned. Development that doesn't interfere with koala habitat but is still within a koala habitat area will be assessed by local government against new planning assessment benchmarks that were introduced into the planning regulation. If you'd like further information or details on those amendments, I recommend there's a very well-written article on our Clayton Utes website. I can't take full responsibility for it. It was a co-authored article. Also in the nature conservation space, in August 2020, the state introduced new regulations under the Nature Conservation Act. They commenced on 22 August and they create two standalone regulations, one for protected plants and one for protected animals. There was also consequential amendments to the existing protected areas management reg, which was needed to support the new standalone regulations. As a consequence of the new regulations, the existing wildlife and wildlife management regulations were repealed, as was the administrative regulation. The new animals regulation introduced a new wildlife licensing framework, as well as 2 new classes of species, being extinct and critically endangered. The general authorisations that removed the need to hold the licence or permit were actually retained within the animals regulation, and that includes for local governments and rail officers. The new plants regulation retained many of the existing provisions from the repealed regulations, but in a more streamlined approach. And importantly, allowances for taking protected plants under the plants regulation, such as under a conservation plan, under a clearing permit or any applicable exemption, were retained. And there weren't many significant amendments to those provisions. However, there have been some changes in terminology. Again, if you'd like further detailed information, I also recommend another excellent article on our CU website. Moving to environmental offsets then, the Environmental Offsets Act, when it commenced in 2014, established a new and current legislative framework for the delivery of offsets, which was supported by a single environmental offsets policy. One of the features of that 2014 offsets policy was that it provided a mechanism for the evaluation and review of not only the policy but the broader framework that was to be undertaken within 5 years of commencement. The state government commenced its review into the framework, and following the release of an initial discussion paper in February 2019, it undertook consultation with various stakeholders across Queensland. And in October 2020, it released its final report, being the consultation and response report into the review into the environmental offsets framework. The findings from the report will be implemented in 2 stages. Stage 1 involves non-regulatory improvements to the existing framework, including, according to the report, increased depth of partnerships with existing land managers, as well as the establishment of a multi-sector reference group. That reference group, according to the report, will include representatives from conservation groups, First Nations people, agricultural and land management groups, development, extractive and energy industries, ports and economists. The reference group is intended to be established in order to assist the Stage 2 reforms, which are due to commence in early 2021 and also due to be completed before the current environmental offsets regulation expires in 2024. Now, details aren't yet known of what Stage 2 will actually involve. However, the report indicates it could involve regulatory reforms, such as legislative amendments to simplify the legal security mechanisms required currently for environmental offsets, as well as establishing the foundations for an offset market. As I mentioned, the details aren't known yet what that would look like and what those legislative amendments might entail, so it's certainly something to look out for in 2021. At the federal level, while there's been rumours of reviews into the EPBC Act offsets policy, which was first which was made in 2012, nothing formal has yet been announced in that space. But it was interesting to note, at least last week, the Commonwealth Government has entered into a memorandum of understanding with the WA Government in relation to the Pilbara Environmental Offsets Fund. That fund was established by the WA Government in order to facilitate landscape-scale environmental offsets in the Pilbara. The fund effectively receives payments in and then distributes offset funds to particular projects and activities in the Pilbara where permitted by conditions of the state approval or by EPBC Act approvals. Interestingly, the MOU doesn't automatically result in an offset condition requiring payment under an EPBC Act approval to the fund, and it's interesting because the current EPBC Act policy actually directs that 90% of an offset requirement be met through a direct offset. It should be noted that the MOU is neither legally binding or enforceable, but under the MOU, the Commonwealth Minister has undertaken to consider the use of the fund to achieve an offset under an EPBC Act approval on a case-by-case basis, but having consideration for the EPBC offset policy. So it'll be interesting to see how and whether that works in practice. Taking a look then at trends in enforcement and compliance in 2020, at the state level, the Queensland Government introduced a range of COVID-specific tools for environmental authority holders and development approval holders alike to effectively ensure that operations could respond to COVID restrictions and remain compliant with their approvals during the declared public health emergency. We have extensive resources on our Clayton Youth website page. However, if you would like further information on any of those tools, please feel free to reach out to any one of us. The Department of Environment and Science has also announced its strategic compliance priorities for 2021 period will focus on the waste management industry specifically and compliance with the waste levy. The CSG industry in relation to storage and management and treatment of CSG, re-injection of groundwater, management of salt and brine, waste hydraulic fracture, simulation, and also air quality, and also mining and resource companies for compliance with the legislative requirement for estimated rehabilitation costs. At the federal level, you may have seen this in the media, but the Auditor General released a fairly scathing report, audit report into the referrals, assessment and approvals of controlled actions under the EPBC Act. And it found that almost 80% of approvals that were examined in the audit were non-compliant or contained errors that meant that conditions could not be properly enforced. The report found that referrals and assessments were not administered effectively or efficiently, and this resulted in an average overrun of approximately 116 days or 4 months for statutory timeframes for approval decisions in the 2018-2019 period. The report concluded that despite multiple reviews, audits and parliamentary inquiries since the inception of the EPBC Act, the Department's administration of referrals, assessments and approvals of controlled actions was not effective. The Department was unable to demonstrate that conditions of approval are appropriate, conditions are not assessed with rigour, and the absence of effective monitoring and evaluation limited the Department's ability to actually measure its contribution to the objectives of the Act. The Auditor General made 8 recommendations to the Department in relation to the EPBC Act, and all 8 have been agreed to. And these include, among others, that the Department will conduct an up-to-date risk assessment of non-compliance across its regulatory regimes and to develop arrangements to prioritise strategic compliance assessments. More importantly, it will also improve quality controls to ensure conditions of approval are enforceable, appropriate for monitoring and compliant with internal procedures, but also that they align with the risk to the environment that the project presents. So I would absolutely suggest that you will need to watch this space in 2021.
Well, thanks, Ian. Now it's my turn. And continuing our review of the year that was, I wanted to look a little bit forward about the year that we can anticipate. I know we're all desperate for it to turn over on 1 January and the world's going to change. But I think from the environmental protection space, the continuing theme from what Ian just presented that I see in terms of accountability arising. And the 3 areas that I wanted to discuss briefly today focus on rehabilitation for mining, particularly in Queensland with the rollout of the Progressive Rehabilitation and Closure Planning Process, PRCP process, so accountability for rehabilitation, human rights litigation, accountability for decision making, having regard to human rights, and what is the buzzword in the boardrooms at the moment, ESG. So initially, in terms of the PRCP process. One of the factors that mining will have to account for from now is developing a progressive rehabilitation and closure plan. Now, those are the new regulatory instruments which a mine will have instead of its plan of operations, which sets out how it will achieve progressive rehabilitation as soon as practicable when land becomes available. And the PRCP schedules, when approved, will be a compliance instrument that are enforceable. It's an offence to not comply with your PRCP schedule once approved. And those PRCP schedules can also be accompanied by conditions of approval of the PRCP, and they are audited every 3 years with an audit report to the department. So these documents as instruments also cannot be or avoided compliance with on the basis that you develop transitional environmental programs. If you have a change in your PRCP milestones or a change to your rehabilitation program, then you will need to factor in an ability to seek an amendment. So why is this something looking forward? Well, certainly the transition process for existing mines has begun. Now, the department had a 3-year period from the commencement in November 2019 to roll in requirements to apply for PRCPs. So the department is issuing transition notices to mines, and once their transition notice has been issued, there'll be a specified time frame of not less than 6 months to address and submit a PRCP. Now, the existing rehabilitation and closure outcomes in the Environmental Authority and other land outcome documents can be transitioned into the PRCP schedule. And so what that means for existing mines is that existing mines will need to look very closely as to what opportunities they have to transition existing arrangements into their new PRCP. The process for approval of a PRCP plan is similar to a site-specific application for an environmental authority, with an application stage, an information stage, a notification stage and a decision stage. And the PRCP plan requirements are set out in guidelines, in the regulations and in the Act itself, and they are quite extensive. In particular, you will have to identify your post-mining land uses, areas where you do not have a post-mining land use or that cannot be rehabilitated to a stable condition, such as those what we call NUMAs, and areas where you have a post-mining land use. Also, the PMLU and NUMAs need to be consistent with consultation with the community, or alternatively the information provided with your PRCP application as to where there are departures from consultation with the community or community aspirations for your rehabilitation. As I mentioned, land outcome documents, which include your EA approved management plans that you may have submitted pursuant to conditions of your EA, or EIS assessment reports, can be transitioned within your PRCP. It's not mandatory to do so, but if you transition the outcome specified in land outcome documents into your PRCP, there are exemptions available from some of the process requirements that would apply to a new PRCP. So, for example, if the land outcome you are proposing is the same or substantially similar to what is in a land outcome document, then you, for your PRCP application, avoid public notification, may avoid the limitation on voids in a floodplain, will avoid public interest evaluation of your PRCP, and also some of the regulatory requirements for assessment of a PRCP will not necessarily apply. So what does this mean for transitioning your to a PRCP if you are a mine? Well, firstly, those transitioning need to determine what its land outcome documents are and what the rehabilitation outcomes are and what the hierarchy of those are. The Act prescribes a hierarchy of land outcome documents, such as if you have 2 or more land outcome documents, then the outcome in the environmental authority takes precedence over management plans, which takes precedence over EIS assessment reports or other agreements with the department. So it is important to understand what that hierarchy is when you are developing your PRCP. Also, when developing the PRCP, if you want to take advantage of some of those transitional protections and avoid some of the process requirements that apply to new PRCPs, then you need to ensure that those transitional protections are not lost when you transfer your land outcome from your land outcome document to a PRCP schedule. So, for example, if your land outcome was grazing in your EA and you want to transition that to the PRCP schedule, you need to ensure that it applies to the same land, and in that case you would avoid public notification of your land outcome through your PRCP. You would avoid the assessment against the environmental protection regulation as to the land outcome that applies, and also the administering authority in assessing the application will have regard to what your land outcome document was or what your EA was at the time, although note that the administering authority is not bound to agree with your land outcome document or automatically transition your EA criteria, but certainly it must be considered by the decision maker. Other practical considerations in developing your PRCP are whether the outcomes for the land in the land outcome document can be easily transferred into the new format for the PRCP schedules that sits behind the guidelines. So, for example, there are specific provisions in those guidelines requiring you to identify post-mine land use, the area that applies to, and when each area becomes available for rehabilitation. And certainly what you'll find in EAs at the moment, while there will be an indication of post-mine land use, it generally doesn't specify the area that it applies to, and certainly rarely would specify when that area should be rehabilitated other than in a very high-level way. Secondly, you need to ensure that there's sufficient flexibility in the PRCP schedule milestones to minimise the risk of triggering an amendment to the PRCP schedule, because the amendment process is going to follow the EA assessment process effectively unless it's a minor amendment, and there are limitations to when a PRCP amendment is a minor amendment. Amending a PRCP schedule, it's also important to note, doesn't have the benefit of these transitional exemptions that will apply to this first PRCP, and also be aware that if you have a planned EA amendment, that would need to be consistent with your PRCP, or else it could also trigger an amendment to your PRCP. So this initial PRCP is quite important to get right to give you that flexibility for the future. Another area which is a fairly new area for resource projects is the change to the surrender requirements. So in August this last year, there were amendments introduced to the Environmental Protection Act in Queensland here, which changed the surrender requirements on a surrender application for an environmental authority. For non-resource EAs, a final rehabilitation report is still going to continue to be required to report compliance with the EA and whether the land is satisfactorily rehabilitated. But for resource EAs, there's a requirement now for a post-surrender management report, which is to contain a risk assessment, and where there are residual risks and credible residual risks post-mine or post-petroleum activity, then a residual risk management plan needs to be developed. And if there are residual risks that are identified for a particular parcel of land, those residual risks will be noted on the land title. There are a number of matters that will need to be settled for this new residual risk framework in the coming year. There is currently an interim guideline that was released in October 2020, but it does not cover all of the requirements for this residual risk framework. So if you are doing a risk assessment, then that risk assessment must comply with the residual risk assessment guideline. And currently the interim guideline doesn't prescribe a methodology for doing that risk assessment. It also doesn't specify how you determine what your residual risk payment is. So this is the payment that at the end of the project's life will need to be made to the state as a one-off payment to cover the risks of ongoing management actions to prevent residual risks or to rehabilitate if a residual risk occurs. So there's no methodology for resolving how you calculate that residual risk payment. So it is certainly a watch this space for now, and it will be developed, I assume, through this new residual risk guideline. Furthermore, in terms of the current interim residual risk guideline and looking forward to the new one, there are a number of matters that will need to be considered. So, for example, with monitoring and management to prevent failure mechanisms, just because there could be failure mechanisms doesn't mean that you need monitoring and management. How will that be addressed? Also, in terms of ongoing management activities, are they to be determined as being required in perpetuity, when clearly some ongoing management will, reach a point where it doesn't need to be maintained. So, for example, revegetation of a site over time that becomes self-sustaining in the future won't need to be perhaps maintained or monitored in perpetuity. How will those matters be addressed? There's certainly some areas for further consideration that will need to be considered in due course as part of this residual risk framework. So changing tack as to, another area of accountability that has arisen out of matters from this last year, and I watch this space for the future, is human rights litigation. And this is an additional consideration for projects in the future. The Human Rights Act was passed earlier when commenced operation in 1 January 2020. And it recognises 23 human rights and places an obligation on public entities to uphold human rights when making decisions, creating laws or setting policies. And certainly the human rights, a range of human rights cover the right to life, the right to property, and a range of other basic human rights. And there's an obligation on a public authority to act or make a decision in a way that is compatible with human rights. In other words, not to act inconsistent with those human rights, or in making a decision not to fail or give proper consideration to a human right relevant to that decision. Now, what has happened, and apparently over the last 12 months here in Queensland, is the Human Rights Act has opened an avenue to interrogate decisions that affect the environment, but on human rights grounds, such as in respect of the impact of climate change. And so this other future area for accountability of our decision makers applies to ministers, local governments and local government employees, courts and tribunals when acting in an administrative capacity, members of parliamentary committees in an administrative capacity. Where has it arisen so far? I think an area to watch for the future is certainly in the resources space and in the climate change litigation space that Kathryn spoke about. There was a decision of the Land Court in Waratah Coal earlier this year where objections to the grant of a mining lease were made on the basis that they would contribute to greenhouse emissions, climate change and its associated impacts on natural disasters, extreme weather events, but on the basis that any decision to approve the mine would be incompatible with human rights, including the right to life and the right to property. And that challenge has been made to the grant of the mining lease in the Land Court. The applicant for the mine sought to strike out these objections on the basis of the Land Court did not have jurisdiction to consider human rights. However, the court found that it can consider an objection on human rights, not only that it can consider, but it must, as it acting in an administrative capacity, make its decision that is not inconsistent with human rights. So the Land Court has accepted that human rights are an important part of its decision-making process. Now, this wasn't a substantive hearing on whether or not human rights would be affected, but rather whether the court had jurisdiction or, in fact, in this case, was compelled to take human rights into account. So it's certainly a watch this space as to see not only where that matter goes, but where other decisions will be considered in the context of human rights. And that leads fundamentally into ESG, which is a topic that is making waves in the boardrooms across the country at the moment, with the three central tenets measuring the sustainability and ethical impact of an organisation through its environmental performance, through its social performance, how it manages its relationships with employees, customers and the community, and with its governance systems being systems in place for management to act in the best interests of its shareholders and in an ethical capacity. And a failure to meet ESG can lead to reputational risks, financial risks, legal and governance risks. Now, the principles that sit behind ESG have been around for a long time and have been considered in the historical assessment of projects. And two cases just to remind people of where, the concept of social impact, social amenity have been considered extensively in decision making, were the Gloucester Resources case and also the Warkworth mining case. And in Gloucester Resources, that was an application for a coal mine heard by the Land and Environment Court in New South Wales. The court determined the project would have significant negative social impacts on people's way of life, community, access to and use of infrastructure, services and facilities, culture, health and wellbeing, surroundings, fears and aspirations. So certainly the courts have, at least in that case, considered social impact and impact on culture, health and well-being, community spheres and aspirations as relevant to decision-making on whether a coal mine should be approved. And the earlier case of Warkworth considered these issues in the context of economic impact. So the association who challenged the proposal mining in the Hunter Valley alleged that the economic assessments did not consider broader community in the state, the nation, who would suffer from reduced natural and cultural environment of the village that would be impacted if the project was approved. And the proponent was unsuccessful in the Land and Environment Court, and the proponent further appealed to the Court of Appeal, which held that the judge in the Land and Environment Court could properly make findings, amongst others, that the cost-benefit analysis was only concerned with the aggregation of costs and benefits, but did not consider equity or distributive justice as part of that cost-benefit analysis, and therefore was of limited value in deciding whether or not that should be approved. So certainly those issues of social impact as part of ESG, in addition to environmental impact, have been considered by the courts before. The case, or the recent outrage over the Juukan Gorge loss of the archaeological caves at Juukan Gorge in the Pilbara region shows, however, that the issues of ESG have further reaching implications, such that even if approvals are in place where it is a matter outside what should or is regarded as an appropriate community expectation, that a project can end up in quite difficult circumstances. And so what Juukan Gorge event has brought to light the questions over whether or not sustainability reports and engagement of the particular proponent in that case with the community was adequate, notwithstanding the approvals that they were acting under. And so the Juukan Gorge circumstance has really thrown the ESG into the spotlight, and also in terms of the ESG ratings that are available now for a lot of organisations. So what happens now is there's a proliferation of what are ESG ratings tools to rate a company's environmental, social and governance risk on a range of specific issues, including pollution emissions, human rights, their responsible management, and these ratings tools are used by agencies or developed by agencies having regard to a range of publicly available information, third-party research, sustainability reports, to develop what goes from a qualitative system to a quantitative scoring system. Now, companies who have developed these rating systems don't necessarily follow a consistent framework, and there's not a lot of comparability between some of the rating system, and the OECD has really recently noted that these various ratings tools aren't regulated, and they are based on systems that are different across the various rating tools using different ESG metrics. So even though there are ratings tools, and these ratings tools are being used by investors and financiers to assess their exposure to ESG related risks and inform sustainable investments, these types of ratings tools aren't necessarily comparable and they should be carefully interrogated by those persons who are relying on the ratings tools that are available. So what does that mean for organisations going forward, particularly in the year of 2021 with increased accountability? Certainly, I think that corporate Australia should look a bit more closely to build stronger connections between their financial and non-financial performance. You can see from the Duke and Gorge matter how non-financial matters can impact on financial outcomes. Building a more robust approach to analysing risks and opportunities from ESG matters such as climate change, social performance, and looking more closely into the non-financial reporting processes, using some stronger discipline and controls in that non-financial reporting such that it is as accurate and clear as possible in order to build community confidence, investor confidence and trust in the non-financial reporting tools. So these are matters that for 2021 I think will be a significant issue for corporate Australia going forward.
Thanks, Kathryn. We've just got a few questions, but we are running out of time. So if you do think of questions, please feel free to email any of us and we're happy to help. The first question is to explain a little more the treatment of the water trigger in the EPBC bill. So just to take a step back, so the EPBC Act was amended in 2013 to introduce the water trigger. That applies to coal seam gas and large coal mining developments that impact on a water resource. Part of the amendments that went through with that bill prevented the water trigger being devolved to the states through approvals bilaterals. What the bill that's currently before the Senate proposes to do is to undo that restriction so that approvals for the water trigger can actually be devolved to the states, territories or other decision makers through approvals bilaterals. It's actually quite an interesting question, and it's been a criticism of the bill that's been raised throughout submissions in the hearing that what Professor Samuel has proposed through his interim report and presumably through the final report as well is a whole package of reforms that are really underscored by fundamental reform of the EPBC Act as well as the National Environmental Standards. What the bill before the Senate does is deals almost exclusively with the devolution of Commonwealth powers to the states. So it's like the devolution is happening without the full package of amendments being made to the EPBC Act. What Professor Samuel recommended in the interim report was that the water trigger actually be modified so it's focused more on cross-border water issues and not necessarily restricted to industries being large coal mining and CSG, which I think he calls a regulatory irregularity. Second question, I think, Ian, is yours. Interested in the statement that DES will be focusing on waste management and compliance with the waste levy in 2021. Any insights into how that will happen? Get your crystal ball.
I don't need a crystal ball. The department, if you go to the department's website, they've actually got a fact sheet which is just titled Annual Strategic Compliance Priorities 2020-2021. In terms of what they're looking at, it says that the targets will be the top 70% of total waste levy contributors, in brackets landfills, that will be inspected, including volumetric surveys undertaken. 90% of alleged unlicensed waste operations will be inspected within 4 weeks of coming to the department's attention. And 90% of illegal dumping incidents that are reported to the department, at least, will have investigations commenced or be referred to local government within 4 weeks of notification. So I don't have a crystal ball, but take the department at its word in relation to that fact sheet.
Next question is also yours. How does the new koala habitat mapping in SEQ interact with DCC, or presumably just local government koala mapping?
There is a disconnect between, like many aspects of state mapping, there's a disconnect between state interests and the local matters that are mapped through planning schemes. One of the things that the August 2020 update did was to clarify what's known as locally refined koala habitat area. It's effectively still koala habitat area, but it acknowledges that there may be locally significant vegetation which is otherwise protected through the planning scheme. And there's a process whereby over the next 2 years that the state government will work with local governments in order to bring the locally refined koala habitat into the broader umbrella of koala habitat areas. How that operates with the SDAP code and planting assessment benchmarks in the regulation, however, may still need to be worked through, because that will really just address the mapping as opposed to the assessment framework.
Thank you. That's it for questions and all from us for today. Thank you so much for joining us. Hopefully next year when we do this one, we can actually do it with a glass of wine. So we wish you all the best for the rest of the year and 2021. Thank you.